Eric and Kouri Richins seem to be living the perfect little life. The attractive couple had 3 young boys and were doing very well financially living in Utah. But beneath the exterior, something else was happening. Family members say Eric suspected his wife of trying to poison him. Eric got so suspicious that he changed his life insurance and will to give his money to his sister, who he trusted to take care of the kids. Prosecutors say Eric was right. He died in March of 2022, a victim of fentanyl poisoning, and they now have charged Kouri with his murder. Today, Corey Richens was back in court, and we have the latest from the hearing. And in Las Vegas, Nevada, a former politician accused of murdering a journalist who reported on him is standing trial. And now all of the evidence is in, and Robert Tellis's fate is in the hands of a jury. We are on the ground with the latest from Deliberations. Plus, a Mississippi teenager is accused of killing her mother and attempting to kill her stepfather. Today, Gregg was back in court where she rejected a plea deal that could have sentenced her to 40 years. Was this the right choice? The think tank weighs in. Welcome to Closing Arguments. I'm Jenaé, filling in for Vinnie Politan tonight. And our top story is a child grief author who is accused of her husband's murder. Kouri Richins, she was in court for day 2 of a really important preliminary hearing, one that is crucial for her defense. It's one of their first opportunities to cross-examine the state's witnesses that may be showing up at a future trial. We're a long way off from that, but we are going to hear from Court TV legal correspondent Kelly Craft. She is on standby with the biggest developments from today. But before we get to the news of today, we want to remind everyone what matters most in this trial, and that's getting justice for the victim in this case. His name is Kouri Richins. And what we know about him is that he was a successful businessman. He was studying at the University of Utah, and he met a friend named Cody, who he started a business together with. They called it C&E Stonemasonry. And while they were working this business, they also agreed to take out a mutual life insurance policy on each other, just in case the worst happened. Years later, business was booming. Eric was comfortable financially, and his life path led him to meet a cashier at Home Depot, where he was going regularly to pick up things for his business. And after a friend nudged him to go ahead and introduce himself to this woman, he did, and they hit it off. The friend later described that meeting as a fairy tale romance. They dated, they got married, and on June 15, 2013, they tied the knot, later welcoming 3 sons into the world. They had millions in the bank, a beautiful home, a great family. You would call it the picture-perfect life. That is until Kouri Richins ran into some financial trouble. She was using, according to the prosecution, Eric's money for flipping houses. It was a side hustle that she was doing, but it landed her in a lot of debt. And the state says that it was hundreds of thousands of dollars that she was stealing from her husband, that he was unaware of what was going on. She was putting credit cards in his name and running up debt. But the state says he found out and that the marriage began to sour. Prosecution claims this was Kouri Richins' motive for poisoning Eric, to get him out of the way, to collect on the insurance policy that he had. But what Kouri didn't know was that prior to his death, he had taken her out of the will and off of the $500,000 life insurance policy that he had. The state says she needed to come up with a new way, to come up with some quick cash. Prosecutors say this is why Kouri wrote that book. The grief author that we talked about that she is, it's because of a children's book called Are You With Me? It was based on Kouri Richins' death, and she told people it was to help kids who have lost a parent. She actually got on TV to talk about this book, saying that she was a grieving mother. So the question is Kouri Richins truly a grieving mother, mourning the loss of her husband, or did she kill the father of her children just for financial gain? Let's get some answers to some of those questions that came out in court today. Let's go live to Court TV legal correspondent Kelly Craft, who is inside of the courtroom. She has all of the biggest developments from today. Kelly, tell us what happened today in court. Who did we hear from?
Good evening to you, Julia. So first, what took place in court today, the judge wanted to confirm with the state that it had rested its case. When the judge did that, the state said, yes, we have rested. Then we heard arguments from both the state as well as defense counsel in regard to all of these charges. And then what did the judge ultimately decide? So this is a probable cause hearing. So the threshold is very low in a probable cause hearing, kind of like the evidence you need for a search warrant or an arrest warrant. And so the judge emphasized that in court today, saying the bar is very low here and I need to look at all the evidence in the light most favorable to the prosecution. And when I do that and take a look at all of this evidence, I find that there is sufficient evidence for someone to reasonably believe that the defendant did commit all of these crimes. And so he found that Kouri Richins can go to trial on every single one of these charges. So 11 charges, the most serious, of course, first-degree murder, then attempted murder. Also, a number of charges in regard to financial crimes, forgery, insurance fraud, mortgage fraud, also distribution of a controlled substance, Julia. So big day here in Utah. We found out that Kouri Richins is going to face a trial on all of those charges, and the trial is set to begin April 28th.
A really big
next
day.
year.
Really big day to understand what's ahead for this case. So this was a chance for the defense to understand exactly what the state has, exactly what they are arguing in this case. Can you flesh out more of what we learned about the state's argument here?
One of the things that the state really focused on, Julia, is that attempted murder charge, because I think that's the one the state thought it was going to have the most trouble with in regard to getting the judge to agree that there was probable cause to get that one to go to trial. But the judge did ultimately decide that she can face charges on that attempted murder charge, of course. So what the state did talk about in court today is that on Valentine's Day, Corey Richens ordered a sandwich, ordered lunch for her and her husband. Eric started to eat this sandwich, and then he became violently ill and needed to, in a way, he called Corey and said he needed to seek medical attention. And what did the prosecutor say that Kouri Richins texted him? He said that Kouri Richins said, take a nap. And so what the state is alleging is that Corey tried to kill him on Valentine's Day, was unsuccessful, but learned from that and then was successful 3 weeks later in killing him. Let's listen to some of the state's argument.
The drug dealer is the same, the timing is the same, but she learned. She learned she needed something stronger. She also learned how to administer it. She learned that putting it in a sandwich where Eric Richins could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richins would throw it back all at once. She says that in her journal article, her journal note at Exhibit 49.
And Julia, the state didn't even spend a lot of time talking about the most serious charge, the murder charge, because it felt there was plenty of evidence for the judge to decide. There was probable cause evidence for that one to go to trial. So really the state just focused on that attempted murder charge, and the judge did agree with the state that there is enough evidence for that one to stand.
Okay, and I've got to ask, because we know the defense didn't just sit there and let that happen. How did they respond to this? Do they have an argument against this attempted murder charge that's going forward?
They absolutely did, Julia. When defense counsel got up there, the defense counsel actually spent some time in the beginning focusing on the most serious charge, the first-degree murder charge, trying to argue that there is not enough evidence for that one, not enough probable cause evidence for that one. But the judge obviously disagreed with that. And so then defense counsel did go into an argument about the attempted murder. Why don't we go ahead and listen to some of that argument?
You have a claim that Mr. Richins was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing but pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning. Just because, I mean, it's like a backwards acting in conformity argument.
The judge disagreed with that argument, and so again, Corey will go to trial on that one as well, and both of them are very serious, the first-degree murder as well as the attempted murder, because both of them carry penalties 5 years up to life behind bars. Julia?
Kelly, before I let you go, what was the final outcome in terms of where we go from here? Because we know a trial would be on the horizon, but we're not there yet. What was the final word we heard from the judge inside the courtroom, and what happens next?
The judge, Julia, really provided a very detailed explanation of his reasoning in this case, of course, making a clear record just in case anyone comes up with this on appeal, saying again that he made the wrong decision. But why don't we go ahead and listen to some of the things that he said today in court. Again, he really explained it well and wanted to make sure that everyone understood that regardless of his ruling today, Kouri Richins is presumed innocent. This just means his ruling today means that she can stand trial for these charges. Let's listen to some of his reasoning.
In January of 2022, Kouri Richins secured a life insurance policy on her husband's death, or her husband's life, through fraudulent means. That she had a significant financial incentive to secure his death because she would do better under the premarital agreement if he were dead, and her businesses were highly leveraged. That on February 14, she purchased food for them both, including him. She described it as lunch in her text message to her friend in June. She was not honest about where she was going that day or what she was doing after she left the family home. Eric had a significant reaction to something that day, sufficient to make him consider going to the hospital. The state has admitted evidence that fentanyl can cause a serious reaction. There's significant evidence, at least to support a probable cause finding, that Ms. Richins had secured fentanyl by February 11th, and that on or about February 26th, she contacted her source again and said she needed something stronger.
After the judge made the ruling and when court concluded for the day, we noticed many of the family members of Eric Richins embraced outside the hallway of that courtroom. Defense counsel obviously not pleased with the decision, saying they look forward to Corey Richins' day in court. That's the latest from here in Park City, Utah. Julia, we'll send it back to you.
Kelly Craft, thanks so much for the latest. Let's bring in tonight's think tank. Joining us, trial attorney and fellow of the American College of Trial Lawyers, Ann Brumner is with us. Also joining us, trial attorney and former police lieutenant Rick King, and criminal defense attorney and former federal prosecutor Michael Sterling. Everyone here, great to see everyone on this Tuesday. And let me start with you. Not surprising that the probable cause hearing went well for the state, but what are your biggest takeaways hearing what happened in court today?
Well, first of all, that judge is awfully young. That's what I thought to begin with. But he was excellent. He was articulate, and it reminds me of the times I've had to listen to a judge doing findings, and you don't know what they're going to say until the end, but as they go along, you get the whole idea of where they're going to end up. So it's a strong case. I don't know why the defense would be that disappointed or surprised. I mean, in that argument that we just heard from the defense, I don't think is very persuasive, but here we go. I mean, it's an interesting case. The children's book that she writes for her kids to cope with the death of the husband she murdered, can't make that stuff up.
You really can't. And I'm wondering, Rick, if the children's book interview that she did before this happened, if that's going to come in as evidence, if that's something to show, maybe not consciousness of guilt, but perhaps financial motive after everything was said and done?
Well, it's obvious that the judge feels that way. I mean, he talked about it explicitly. He said that, hey, she had a financial gain with him being dead. And at the end, this was a probable cause hearing. So what we're actually saying is that, yes, a crime was committed and that probably she did it. And so that's a very low threshold to make. The judge found it. And then as a motive on top of that, they talked about the amount of money that she would have stood to gain from the book. So I think that there's the combination of everything probably led to a bad decision for the defense in that case, but it's a very strong case for the prosecution.
Michael Sterling, we've got this other charge that came up during this probable cause hearing. You heard Kelly saying really they talked about it more than they did the murder charge, but that's this attempted murder that happened, according to the prosecution, on Valentine's Day, where she tried to poison him with the sandwich and it didn't work, but the prosecution says it helped her to understand how much she would need and whether or not she would be able to give him this poison. Do you think prosecutors need that charge? Because sometimes these separate events where you may not have enough evidence for one versus the other could confuse a jury.
Yeah, I think prosecutors do need that charge. Candidly, I think that that's part of how they tell the story, right? This is how they draw the narrative. What they want to show is that she was somebody who had the intent to murder him, and she was trying to figure out the best way to do it. And I think this charge, even if the jury comes back as a not guilty, because as the defense attorney was pointing out, there's no medical evidence. There's a lot of things that are lacking in terms of getting you to beyond a reasonable doubt. I think that charge will probably, because they'll be able to talk about it, prove it up, and try to work it into the state's case in chief. I think that charge may help them get the ultimate determination on guilty on the final charge of murder.
We will be watching everything in this case. The defense today did put out a statement saying everything in that hearing is very pro-prosecution. We expect that we will clear Kouri Richins of any wrongdoing so she can get back to her life and to her children. We're going to get to a break. The Think Tank is staying with us. Don't go anywhere. We are going to discuss, believe it or not, another day of jury deliberations in the investigative reporter murder trial. The victim, Jeff Garriman, the defendant, Robert Tellis. Stay with us. Plus, coming up in the next hour. Tonight on Vinnie Politan Investigates, young mother Mamta Bhatt was last seen at work on July 27th. She has not been located, but her husband has been charged with concealment of a body. Tonight, we look at what we know about the evidence against Naresh Bhatt.
Join Court TV's Vinnie Politan.
In every story, in every trial, every case, there's at least two sides to it.
To dive into the latest.
Oh my God.
And breaking true crime stories.
This was a very targeted, very personal attack.
Inside.
I've never seen that in a discovery. I've been incarcerated 3 years.
And outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central. Only on Court TV.
You also know that Mr. Tellis took the step of leaving his phone at home prior to the murder. That's indication of premeditation and planning. You know that he bothered to disguise himself by wearing the hat and the orange outfit. That shows premeditation, a decision to kill. And you also know, most of all, that he brought a weapon over to Mr. Garriman's house, and that shows premeditation as well.
A jury continues to deliberate in Las Vegas in the investigative reporter murder case against a former politician, Robert Tellis. Tellis is charged with stabbing a veteran journalist, Jeff Garriman, to death. And his motive, according to prosecutors, it was retaliation for a series of articles that Garriman wrote highlighting alleged wrongdoing in the Clark County Public Office. And after that, Tellis lost his re-election bid, but he says he was framed for this murder. And before the jury got the case, Tellis made one last narrative form plea of innocence towards the jury, saying he didn't engage in crime in general as a rule, and he said he would not have driven his own car if he were going to commit murder. Court TV crime and justice correspondent Matt Johnson has been in the courtroom throughout the duration of this trial. He's joining us now from outside that Las Vegas courthouse. And Matt, it's good to see you. I think you're actually inside of the courthouse. You've got the prime location. What's the latest news with the jury deliberations that have been going on now 2 days and many hours?
Julia, nice to see you. So we're going to enter a third day of deliberations, which is surprising to a lot of people that were in the gallery during this trial, and a lot of the local media covering the case as well. So this jury, 5 men, 7 women, deliberating 10 hours over the last 2 days, taking in a lot of evidence and taking their job very seriously. Today, focusing on one piece of video when they've asked another question, saying they wanted to see the side-by-side comparison video of Tellis walking in a local news report, and the murder suspect fleeing the scene in surveillance video, something that, again, prosecutors focused on during their closing arguments. Take a listen.
And then we have his walk. Like, he's got a little hitch in his getup where he kind of leans to this one side. You can kind of see it. There's something that is about his little walk. And look, you don't have to take my word for it. You can evaluate whether you think what Zach and Christy had to say about it. They've hung out with him. They've walked with him. They thought, and think about how they saw it. They were like, man, they kind of knew the background between Gehrman and Tellus, and they were like, wouldn't that be funny if that was him? He's got those same goofy gray shoes.
And that split screen edit of that video presented by prosecutors in their rebuttal closing was not in evidence during the course of the trial, so that was not given to this jury. The jury will have to compare those two separate videos on their own that are in evidence. And as for the defendant shaking his head during those remarks of little walk and also being called an amateur killer who made mistakes. Julia?
Matt, I'm sensing a theme here with the jury because remind us, yesterday they asked for help with another video, right?
Another video from also these closing remarks from these attorneys, but this one focusing on the video that the defense pointed out. And in their closing remarks, they said, pause the video and take a look at the suspect vehicle and the suspect inside. He appears to have hair and my client is bald. Take a listen to that argument.
You have this evidence. It wasn't part of his presentation, but it's been provided to you. Look at the profile. What's that look like on the top of the head? I'd submit to you that looks like hair. We've seen Mr. Tellis. He gave testimony from the witness stand. Does that profile match the profile in that vehicle? I mean, it's no secret. The man's bald. Look at the face. Look at the eyes. I'd submit to you that those look like glasses. And again, this is part of the evidence collected by the state. It's been presented to you. It wasn't addressed.
So again, this Las Vegas jury, 5 men, 7 women, will be back at it again tomorrow for day 3 of deliberations. And here in Clark County, Nevada, it is a little bit different with the penalty phase because this jury, if he is found guilty, will also weigh in on a penalty suggestion for the judge. And that can range anywhere between 20 to 50 years and then parole to life in prison without the possibility of parole here in the state of Nevada.
Matt Johnson, thanks so much for all of the latest as we gear up for a 3rd day of deliberations. Let's bring back in the think tank tonight. Still with us, trial attorney Ann Bremner, former police lieutenant Rick King, and criminal defense attorney Michael Sterling. Rick King, let me start with you. I mean, this just shows closing arguments matter. These jurors were paying attention, and though it's all demonstrative aids that they want, it still shows that they are struggling with something. Your thoughts?
Listen, as a criminal defense attorney, if the jury is out for 3 days, I am hyped right now because I'm like, something that we did at closing really worked. And I want to tell you that vision of the car with the guy with the hair, as a bald guy, I'm like, listen, that's not me. You know what I mean? So I like their argument. And listen, that guy's bald. There's no arguing that. And that hair right there, that's a closing argument that I love. And the fact that they walk away with that image, to me, is powerful.
I mean, but this is a guy, Michael Sterling, who was wearing a big floppy hat, according to the prosecution. He was wearing this orange getup, so he was wearing a disguise of sorts. But I think in looking at that picture, it's not just the hair that doesn't quite look like Robert Tellis.
Yeah, it's also, the defense pointed out, it's also the glasses. And listen, at the end of the day, what you want is the jury doing exactly what they're doing, pulling in, saying, hey, let's see the video again. Let's see the walk again. Let's see the picture that the defense showed us again. Because at the end of the day, Julia, as you know, it's beyond a reasonable doubt. So if the jury is in there and they're 50-50, they're halfway, they're like, maybe, you know, someone is going to say, let's look at what the law requires us to do. And that's why it's important in your closing argument to talk a little bit about the law and say the law says it's got to be beyond a reasonable doubt. If we have, and we can articulate a reason to doubt, the hair, the glasses, that walk not quite the same, if we can articulate a reason to be doubtful, we have no choice but to vote not guilty. Not to say he's innocent, but we've got a choice. And we have no alternative but to say not guilty because it hasn't been proven beyond a reasonable doubt.
And Bremner, this jury is video focused according to their notes. But if they come back with a conviction, this 3-day process and the fact that they are asking so many questions, what do you think that implicates about sentencing and perhaps how they may view this if they do come back with guilty?
Well, it's favorable for the defense. I mean, if they've got people, especially if it's a compromise verdict, Julia, I mean, like, what if you have someone that says, I really don't think he did it, but, you know, I could be persuaded to go to, and we can be lenient in sentencing. And I also think, you know, for jurors to sit and think, would a guy that's got this kind of, you know, political career go kill a reporter, you know, over an expose? It's kind of astonishing. So in looking at the motive, there could be doubt there too.
Yeah, Rick, last question before we have to go to a break, but him taking the stand, it's brought a lot of criticism about this narrative style, why he did it, why the state agreed to it, and he rambled on for 2 days, it felt like, for us watching this, because it seemed to meander. But he was able to really show the jurors himself, perhaps nervousness, perhaps some fumblings, and maybe they don't think that's the kind of person who could 100% commit this brutal murder.
That's 100% possible. And like when I realized what he was doing, for me, because, you know, as criminal defense lawyers, we know if the defense lawyer is not asking questions, it's because they don't want to support perjury. So that's one of those things that, we just happen to know. However, like to Michael's point, and this is the biggest thing ever. So, and I know Michael has said this, I know Ann has said this, I've said it at closing arguments when we say to the jury, hey, listen, if you think he might have done it, it's not guilty. If you think he could have done it, it's not guilty. If you think, I'm not sure, but I think he did it, not guilty. And that's what they did here, and that is what's powerful. And that's why, like, for 3 days out, the defense is feeling confident right now.
So, Michael Sterling, if this goes to a sentencing, do you put Robert Tellis on the stand again, knowing that the state is going to be able to put on victim impact statements of those who knew Jeff Garriman?
It's possible, but sometimes in a sentencing, you get what we call residual doubt. So it was that it wasn't beyond a reasonable doubt, but you get a juror who says we had some residual doubt, and you get a very, very lenient sentence because they either compromise on the verdict and then says, okay, well, we'll figure this out at the sentencing, and you get what we call residual doubt, which is a very lenient sentence for a crime like this.
All right, well, we have to leave it there. Think Tank is staying with us because we are about to switch gears to another story. We're going to Mississippi for this one, where an accused teen murderer, Carly Gregg, she was back in front of a judge today for yet another pretrial hearing. We've seen her sitting there inside of the courtroom. She's been charged as an adult in this case. We have a major development that came out of that hearing today. We'll tell you what it was next, right here on Closing Arguments. Stay with us.
All right, Ms. Gregg, same thing. We've done this with you before. The first charge that you have is first-degree murder. The second charge you have is attempted murder. You have been detained at this point up to 56 days. Your current bond is $1 million. You recently turned 15 this past month. The same thing is true here in analyzing the circumstances for Ms. Gregg. She is 15 years old. Her mental maturity, physical maturity, her present mental state, I've heard no adverse information concerning that at this point, although I do note that it has been brought to the attention of the court that you have an excellent academic record, which is good, but I've had nothing negative up to today, which we may have more information presented today. The other criteria, the nature and circumstances of the alleged offense, obviously a murder charge and attempted murder charge are extremely violent charges, and they are held in the most serious of circumstances here. There are no prior delinquent acts by Ms. Gregg.
Welcome back to Closing Arguments. What we were just listening to was Judge David Moreau addressing Carly Gregg in a hearing. That was a few months back. Carly Gregg recently turned 15 years old, but she's facing a murder charge. According to the prosecution, she shot her mom twice in the head, tried to shoot her stepfather, and then invited a friend over to look at the corpse. She allegedly used her mom's phone to text her stepfather, Heath Smiley, luring him to the house with plans to kill him as well. According to Smiley, when he arrived, Gregg fired 3 shots, but only hit him once because she had run out of ammunition. Smiley was able to wrestle the gun from her hands, and she fled the scene and was apprehended a half of a mile away. She was back in court earlier today, offered a deal from the prosecution in this case. Let's listen.
All right, we're here by way of pretrial conference checklist, which means that the defendant has rejected any recommendation from the state. For the record, what was the last recommendation of the state of Mississippi?
Here, the state recommended 40 years in the custody of Mississippi Department of Corrections and agreed to not cross counts 2 and 3 of the indictment. Again, there were fines and no contact and things like that.
All right, Ms. Gregg, did you receive that recommendation of 40 years?
Yes, sir.
And it was your choice and your choice alone to reject that recommendation?
Yes, Your Honor.
You know, if she proceeds to trial, count 1, what's the potential sentence?
Life.
If the jury fails to fix the sentence at life, what's the sentencing range?
20 years to 40 years.
All right, and count 2, what's the potential sentence?
Between 20 years and life.
All right. She's 14 years old, so if the jury fails to fix the punishment at life, she's facing 50 years?
Give or take, Your Honor, yes.
Okay. And in count 3, what are you facing?
Another 10 years.
Another 10 years. So the jury will either acquit you, or you'll be facing 2 life sentences, or this court can sentence you up to 93 years. Do you understand that?
Yes, Your Honor.
It's your choice and your choice alone to proceed to trial.
Yes, Your Honor.
Have a seat.
So our question is, was declining this deal a good decision for teen Carly Gregg? Let's bring back in the think tank to weigh in on this issue. Ann Bremner, Rick King, and Michael Sterling all still with us. Michael Sterling, your thoughts on her rejecting this plea deal?
It's tough. I mean, it's always tough when, you know, you're faced with those types of decisions. And I've actually tried a case in Madison County, Mississippi, in front of Judge Dewey Arthur. He's one of the worst judges in the state of Mississippi. He's horrible. And I think that, especially at sentencing, especially with his judicial process and fairness, I think, you know, I could just see what was happening there, and it's not good. And I think that, you know, it's one of those things. It's just a hard decision to make, especially when you're dealing with somebody who's her age. And I always say, Julia, on Court TV, I have a really hard time dealing with the judicial system where we say people aren't mature enough to buy cigarettes at 18 until they're 18. People aren't mature enough to buy alcohol until they're 21. People aren't mature enough to consent to certain things when they're 14 and 15, like sex with an older person. But at the same time, we're saying you're old enough to be tried and and put to a trial as an adult, I have a hard time reconciling those judicial principles. So it's very, very difficult to see this case play out.
It is difficult. Michael Sterling's opinions about judges do not necessarily reflect those of us here at Court TV, but it's important analysis, and especially what Michael is saying about age and consent and the ability to consent, not just about murder and whether she should have been tried as an adult, but we've got this minor status and she's making a decision on whether she should take a plea deal, get 20 to 40 years in this plea deal, which at 14, there's a life after she ends that plea sentence, or she can go to trial. And I know there are adults who are making this decision for her, but what are your thoughts on other people making that decision for her?
Yeah, I agree with Michael's comments, and it is really troubling. When I was a prosecutor, I dealt with juvenile offenders on a federal grant, and so I had a lot of murderers. I never saw any of them get 40 years in murder ones, being tried as an adult, everything else. I mean, that's pretty daunting. And she's got her little plaid outfit on. You know, what grade are you in at that age? It's just really, it's just troubling. And but what she did was pretty horrific too, and pretty premeditated. The last case I had with a juvenile girl on a murder one, she killed her grandpa with garden tools and then went out and bought Pop-Tarts and cigarettes with $20 she got off of them.
Yeah, Rick, I want to talk about what she's wearing. Don't know if it is something that they're just bringing for her to wear because of this trial or if these are her clothes from home, but there's something about the way she's even dressed in front of this judge that is screaming, too young to be here, something terrible must be going on in her mind. But, you know, both of these parties agreed that she's competent to stand trial, but her defense is, of course, still going to go forward with an insanity defense.
Yeah, it's her outfit screamed child, and listen, I'm going to tell you that my respect for Michael Sterling is to this point at the highest esteem. However, what he said today and how he talked about today and was able to say what exactly he thought about the judge in that case, that elevated him to a whole new level. Because here's the thing, like we as a society, we have to decide whether we are. Like, are we comfortable throwing away 14 or 15-year-old kids? And to answer your question, Ann Bremner, at 14, she's either in 7th or 8th grade. Are we comfortable with throwing someone away for 50 years? I don't know. For me, I'm not. And I respect Michael Sterling for standing up to that judge and also standing up for what's right for children. And I just, that's my position on it.
Absolutely. And you want analysts, you want defense attorneys like Kim standing up for Carly Gregg. And Michael, this one's a difficult one because you have victims, you have the mother who was killed for seemingly no reason, no motive behind it. Is there anything else? I mean, she's in this criminal justice system. There are psychiatrists who are analyzing her to make a decision, but you've got the state saying, no, she knew what she was doing and it's fine to charge her as an adult. You're no doubt, we haven't heard from the defense psychiatrist yet because they are still working on that. But what else is there when you have something like this, a situation like this?
It's sometimes there isn't anything else, Julia, and that's the unfortunate part of our justice system. And just so the audience knows, this case is being tried in Madison County. Like, this is a Madison County, Rankin County case. They share the same judicial judges. So judges who handle cases in Madison and Rankin County in Mississippi are basically the same. Keep in mind, Rankin County is a system where you just had 4 or 5 sheriffs who were putting guns into black victims' mouths and who just got convicted on both state and federal charges. Like, this is a system that people have to deal with, where you've had not only corruption at the local level, but you've dealt with things in the judicial system that just systematically have been unfair. And so sometimes there just isn't anything else. You just have to do the best you can do as a criminal defense attorney, as somebody who's working a case like this, as analysts who are trying to explain to an audience who may not understand what's going on. It's just a really difficult situation, Julia. Sometimes there just isn't an explanation, and I candidly don't have one. I wish I could find the words. I just don't have one right now.
And final thoughts, because the way we're all discussing this case, it doesn't sound like it's going to be easy for the state to find a jury that's going to say, yes, she knew what she was doing, she knew right from wrong, and she deserves a stiff penalty.
Yeah, I think it's going to be very difficult. In the case I mentioned earlier, the defendant's feet didn't touch the ground. She was so little, at the counsel table. And she did have an insanity defense. So I think that there's some hope for her defense. But I think Rick and Michael's comments are excellent. And I agree all the way around.
We absolutely appreciate all the analysis of everyone. Thank you to our think tank, Ann Bremner, Rick King, and Michael Sterling. Thanks for sharing your time with us tonight. Up next, we're going to reveal something else you need to know, plus coming up next hour. Tonight on Vinnie Politan Investigates, Mamta Bhatt was last seen on August 27th. But before her disappearance and before his arrest, her husband made some peculiar Google searches. Does his internet history go along with what he told police? And does his story make sense?
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom in America's most compelling cases.
Victim to Verdict with Ted Rollins. New season premieres September 8th.
Only on Court TV.
Welcome back to Closing Arguments. It's now time for us to reveal something else you need to know tonight. Let's take a look. Earlier today, a defendant, Wade Wilson, was given the death penalty for the 2019 murders of 2 Florida women. A jury convicted Wilson for the murders of Christine Melton and Diane Ruiz back on June 12th of this year. Then on June 25th, they recommended the death penalty for each of the murders. 9-3 was the split for the murder of Christine Melton and 10-2 for the murder of Diane Ruiz. Now, earlier today, the judge had a separate hearing, a Spencer hearing, to go over that recommendation, and he agreed with their recommendation, officially sentencing Wilson to death.
Having reviewed all of the aggravating factors proven beyond a reasonable doubt and all of the mitigating circumstances reasonably established by the evidence, the court finds that the aggravating factors greatly outweigh mitigating circumstances. Given the facts of the case, nothing in defendant's background or mental state would suggest that a death sentence is inappropriate. This court's review of other reported capital cases has led the court to conclude that the death penalty is not disproportionate in this case. Under the totality of the circumstances and evidence, the court finds no basis to override the jury's verdict. The totality of the circumstances warrants that the defendant, Wade Stephen Wilson, be sentenced to death for each count of first-degree murder. Accordingly, it is ordered to the judge that the defendant, Wade Stephen Wilson, be sentenced as follows. Count 1, first-degree murder of Christine Melton. The defendant is hereby sentenced to death.
Now, before the judge handed down that sentence, Wilson's adoptive parents had a statement that was read for mitigating evidence on their behalf.
Despite everything, Wade is still our son, and we love him. The hopes and dreams of his life are already lost, but the human is still in there somewhere, tortured beyond what most of us can even begin to imagine. Taking his life will not bring back those 2 beautiful women. There is no justice on earth for that kind of loss. Taking another life only adds to the tragedy. Please see it in your heart not to kill our son and make our innocent family suffer even more. The system designed to help those who suffer and are lost failed him. That system is broken, and it would be only further broken if it took Wade's last breath. That broken system owes Christine, and it owes Diane, and it owes their families, and it owes our family. It owes us all the peace that it did not provide to Wade. Candy and Steve Wilson.